Go ahead, Mr. Merchant.
Your Honor, that was a political speech. Ms. Oliva didn't answer any of your questions directly. She was sent here to say a certain thing, and she said a certain thing. I'm not going to give you a political speech. I'm going to talk about the law. The Open Records Act makes clear, Your Honor, in the very first paragraph of the statute, that it is the strong public policy of this state to be in favor of open government, that open government is essential to a free, open, and democratic society, and that public access to public records should be encouraged to foster confidence in government, and so that the public can evaluate the expenditure of public funds and the efficient and proper functioning of its institutions. That's what these requests asked for. Many of the requests asked for how the DA's office spent money. Many of them have nothing to do with the criminal case, as Your Honor has appropriately pointed out, yet we continue to hear this banging on the table about this being some sort of politically motivated or media motivated type of action, and it is not. We are here because the DA and the DA employees, in particular Mr. Bond, refused to comply with this law. Ms. Merchant and I are fortunate enough to have the resources to be able to put us in this spot so that we could actually argue the law to Your Honor and highlight the failures here. As Your Honor has pointed out, from the first day we set foot in this courtroom, you have been appropriately focused on the real question here, which is, are they subject to the Act? You have ruled in on the motions to dismiss it that the two remaining defendants are subject to the Act. Are the records that are sought public records under 1870A? The Wallace case requires them, that's Wallace versus Greene County, it's 274, Georgia Appellate 776, that's a 2005 case, deals with the idea that they can't just send us a letter within 3 business days and say, hey, we're on that. That's insufficient as a matter of law. Not only do they have to send us something in writing or to let us know that they're going to respond, they have to tell us whether they're going to give us the documents or not. And then reasonable accommodations can be made after that. They haven't even argued that they complied with that portion of the statute. So we've crossed that bridge. They haven't asserted any legal basis for any exemption under 1872. So we don't even have them taking a legal position that they're not required to give the documents in the first instance. So that leaves us squarely on the substantial justification prong of 1873B. That is the remedy in the statute for us. There is no other remedy. You're it, Your Honor. If you say we have failed in this endeavor and you do not grant us, you don't render judgment in our favor and grant us fees and expenses, it is going to send a message across the state of Georgia that virtually nothing that is done by the DA's office in this office or any other place will be held accountable under the law. And we think they have failed to rebut our allegation that they were not substantially justified in failing to comply with the Act. Because I don't think there's any real doubt here or dispute that they haven't given us the documents or didn't give us the documents in time. There's a lot of this, well, we gave it to them, we gave it to them, we gave it to them, months and months later. There's nothing to see here, Judge, because they've gotten the documents now. That's not the issue. The issue is it took us 8 months of litigation to get here. And they only gave us documents in piecemeal fashion only after we forced their hand, only after we filed the lawsuit, and they were held to account for it by filing legal responses to us. It took that, Judge, not picking up the phone and saying, hey, what do you really want there? And trying to find a way to make it more transparent, which has been talked about a lot, and which is the underlying premise of the whole act itself. They didn't do that. They hid stuff. They changed the documents. They altered the documents, and they did it on purpose. I'll get to the Ashley Merchant rule in a second, but as I pointed out in the letter yesterday, Your Honor, 915.14 is our abusive litigation statute in the civil world. This is a civil action. There's no, I couldn't find any guidance in the case law surrounding the Open Records Act that defined what substantial justification for their failure to comply, what that actually means. So I had to go digging in the abusive litigation statute, and that statute specifically defines substantial justification as lacked substantial justification as meaning substantially frivolous, substantially groundless, or substantially vexatious. Well, Frivolous and groundless both can be satisfied by the plaintiffs, by us, by showing that they lacked a legal basis for their arguments. And we've demonstrated that they have not raised any legal basis for their arguments. So we win on both frivolous and groundless under the statute just by showing they didn't assert a legal basis in their defense. Groundless also could include a factual basis, an excuse, if you will, for why they didn't comply. That is where I think Your Honor has some questions to resolve regarding Mr. Bond's testimony. You, of course, with no jury, you're the trier of fact. Sorry,
Mr. Merchant. Let me interrupt you for a second. So, first of all, let me just ground us again for a moment, because it is a non-jury trial, because I am the trier of fact, because, you know, we're forcing procedural pit stops along the way that don't come naturally when it's just a bunch of lawyers in here talking. But technically, what you are talking about right now is a response to Ms. Alabi on behalf of the two defendants' motion for directed verdict. And I understand you need to address each of those elements, but it sounds like you're starting to stray into argument about why you think you should win, as opposed to just argument about why I should direct a verdict against you.
And I was doing that, Your Honor, because I was sitting there thinking to myself, well, am I going to do a closing separately from this with no jury, or am I just going to go up there and talk?
I mean, if you feel like it's all the same thing, I'm okay with that. I just want to make sure that we sort of know where we are.
Yeah.
And the reason I say that is that I would still end up wanting to hear from the county attorneys in terms of their position about the substance of the case, separate and apart from the DV.
Yeah, fair enough, Your Honor.
Okay.
Then I'll focus very specifically on direct verdict issues.
Yes, sir.
So the standard in the civil case is preponderance. So the only thing we have to do is show, Your Honor, that we're more likely than not to prevail, and we have to demonstrate that we've carried the day on certain factual issues related to the elements of the statute. So what we've already talked about, the first two or three elements, we've satisfied all that, because there's no evidence that they raised any defense that would require us to bring evidence to dispute it in the first place. So it's conceded. So the real issue is, did we give Your Honor enough enough facts to reach the trier of fact yourself to consider the issue as it relates to substantial justification? So let me talk to you about Mr. Bond's testimony. So you're the trier of credibility. I think you sat here and you listened to him. We all did, and I think you can understand that our position is he is the personification of the failures in this case. He's the personification of the failures in this case because he specifically testified that he has an Ashley Merchant rule, and the Ashley Merchant rule, which is contrary to his number one rule, means that he doesn't pick up the phone for her, and that he digs in, and he's defensive, and he's obstructionist. The way he testified is exactly how they responded to the open records request. He didn't assume that there was a valid purpose or a legal purpose and then go try to help Ms. Merchant find these things. He did the opposite of that on purpose. He did this because he linked it himself specifically to the timing. And we heard from Ms. Alabi too about this today. He, on the stand, linked it to the timing of the criminal case and the motion that Ms. Merchant filed in that case in January of this year. That's when the wheels fell off, because he wasn't listening. He wasn't trying to comply with the law. He was trying to find a way to parse her requests. He must have said it 4 or 5 times, garbage in, garbage out. So that's his excuse for failing to comply, because he decided, I'm going to determine that's garbage in so I can give garbage out. And he did that on purpose because he was not going to communicate with her. So the excuses he gave, and I think this is something fairly that Your Honor needs to consider, is the credibility of the excuses he gave. Because frankly, under the statute and under the interpretation of the definition of substantial justification, you've got to find, frankly, that you believed him. Not only did you believe him, but that you believed that they were substantially justified in relying on these excuses for failing to comply for some 9 to 10 months. Even in the face of a lawsuit where he I'll get to in a second, claimed he never read, and then said he believed it to be frivolous. So the cyber attack, he claimed at some point that part of the reason they couldn't comply was the cyber attack. That only applied for a very short amount of time. It certainly it's understandable that they would have difficulty responding, at least electronically, to certain things because of the attack. We're not questioning that. But what happened when it was over? They didn't go back and start to redo it and fix it. They didn't do anything like that. And not only that, on the stand, he didn't even attempt to link up the cyber attack with any actual delay. He just said in general terms that they had a cyber attack. He didn't say in this specific case how it prevented him from responding to Ms. Merchant appropriately or timely under the law. Excuse number 2. The January 9, 2024 request was not elevated to him. This appeared to be, from my view, someone trying to throw an employee under the bus. That because it wasn't elevated to me, I was not aware of it. We know that's not true. At the time that he testified to that, he was not aware that Ms. Merchant had an email from September of 2023 with he and Erica Willingham on it, showing very specifically that he had talked about critical mention and that they had actually prepared these documents in the prior year. But he told Your Honor under oath that he had no idea what critical mention was in January of 2024. We know that's not true. When he got caught with his hand in the cookie jar, he tried to pivot around it and then finally had to concede, well, yeah, I did deal with that. That's my name. His name on the email was Dexter Q. Bond. He also told you that he didn't know who Dexter Q. Bond was when Ms. Merchant showed him the forfeiture documents with his name on it. It's just incredible. So he's with regard to the failure to elevate, this is, if it's anything, it's a failure to train the employees properly. Let's assume that he didn't have a nefarious reason for testifying the way he did, and that he was actually telling the truth that wasn't elevated to him. Well, it cannot be the plaintiff's burden. It cannot be the citizens of Georgia's burden to train employees who are dedicated and responsible for responding to Open Records requests. It's just not, that can't be a function and it can't be a defense to justify not timely complying with the law. More importantly, Your Honor, if that excuse held any water, it certainly lost all the water by January 26th because we know he wrote a letter to Ms. Merchant outlining all of the issues. So to the extent it wasn't elevated prior to January 26th, we know Dexter Bond was involved going forward starting on January 26th. So what in the world justifies the period after January 26th through September and even now when we still don't have some of the documents? Excuse number 3, Mr. Bond assumed the first matter was resolved because Ms. Merchant didn't specifically follow up. And when she was on the stand today, I heard questioning about this as well. Did you follow up on every single little thing? And I think Your Honor even asked Mr. Bond, what happens if you say no responsive documents? Is it the plaintiff's burden or the citizen's burden to ask, are you really sure about that? You know, that's not what the law contemplates. The Open Records Act certainly doesn't contemplate us having to cross-examine the agency's responders. We can't do that, and we can't do that for one very important reason, which Ms. Merchant pointed out today. We have no idea how they keep their documents. We don't know who the custodians are. We don't know whether they're stored electronically. We don't know if, in this case, there's an IT department that has superior control over electronic information. We have no knowledge of that. You'd have to be somewhat sophisticated across the board to figure out how different agencies store their documents to be in a position to cross-examine, or, in his words, follow up about things that we may not even know about. I think the 44 pages is very instructive, Your Honor. He was very cagey about that, and he was cagey for a reason. They altered the documents. There's no other way to put it. And
to give the benefit of the doubt, I think it may still be problematic because even if the court doesn't assume that it was intended to obfuscate anything, the holder of the record can't have it both ways and say, I'm not required to create a document that does not exist in order to respond to you, but then in responding to you, create a document. That those two things can't coexist. I'm not as willing as you are to assume that it was intentionally done to obfuscate, but it is still problematic.
Right, and exactly, Your Honor, because I think, you know, he hemmed and hawed about that considerably when Ms. Merchant was questioning him about this, and he could have easily just said on the stand, yeah, that was a compilation that she put together and she took stuff out. He could have said that, but he spent 15 to 20 minutes arguing with her about whether it was a compilation or whether information was actually missing from the document initially. And then finally he conceded, yeah, there's stuff missing. And then he, as an open records officer, we asked him specifically, you know, what's your obligation under the Open Records Act to produce a copy, a true copy of the document? And he wouldn't answer it. He said for some reason he just didn't know. And then eventually he conceded, well, yes, I do have to produce copies. But my larger point, Your Honor, I think is the way he testified is very important, because I think it establishes the mental mindset they had when he responded to these requests. And so I think the reason why that's important, I know Your Honor doesn't want to get into the machinations of the intent, and I totally understand that. But the reason why it's important is because it colors his testimony about these excuses. Because if he can't even tell the court in candor why that document is not an original document and won't concede it's an original document, that's the thing. That's the personification of this problem and why we're here today. So the final excuse that I noted was they were just too busy to comply. That's not a defense to an open records request. It's just not. It's certainly not a defense to an open records lawsuit. They have to find a way to operate within the confines of the law. There's no exception in the statute that says I get a pass because I'm a larger county, I'm a larger agency, I have more employees, or I have more requests. That doesn't carry the day. So that argument falls flat, Your Honor. So, and I'll save the linkage to the legal standard for later, but I think based, and I'll be candid with the court, there's been talk of why we didn't call all these witnesses. We subpoenaed everybody under the sun. We called blah, blah. We intended to call those folks. First, they filed motions to quash everybody. They did not want us to talk to those folks, or did not think we needed to as an initial matter. But two, once Mr. Bond took the stand, I looked at Ms. Merchant and said, I don't think we need anybody else. I think he has just made our case for us because of how he's testified. So that's why we didn't bring a laundry list of folks in here, because it was unnecessary. I think the court has plenty, based on his own testimony, to find that we have overcome a directed verdict. Well, on a final point, Your Honor, before we get into the issues in closing, is this issue of vexatious. Just briefly, and I think if we go back to the number one thing he kept saying, he said, I'm not going to reach out and talk to you. Communication has been taken out. When he does that, and he does it only for Ms. Merchant, he's designed the process to make it more harassing, to make it more annoying, to make it impossible without further follow-up and constant follow-up by Ms. Merchant to get the issue resolved as it's supposed to be, more informally. He forced our hand. There's no doubt about that. We would not be here and we would not have filed a lawsuit had he just picked up the phone and tried in good faith to comply. So the standard is whether or not that's designed to be harassing and annoying. And I think if you looked at his testimony when he was responding to Ms. Merchant's questions, I don't think a single soul listening to him could disagree that he was trying to be harassing and annoying to Ms. Merchant while on the stand, and he actually made it very personal. And I think the fact that he took it very personal and that it was very much a Ashley Merchant issue is what colored the responses by his agency and by him. I think this, and we've seen it today with Ms. Lobby coming in here and arguing things that just aren't relevant at all to the legal inquiry. And the reason for that is they have marching orders. Whether they're appropriate or not in the context of open records is not our fight. It honestly isn't. It's, did they give us the documents when they were supposed to? Do they have an excuse for not giving us the documents when they were supposed to? And if they have an excuse, is it justified under the law? And we think we've shown through Mr. Vaughn and through the evidence that we more than satisfy directed verdicts. We'd ask Your Honor to deny the motion. And on just a separate issue, because I don't think it was addressed, we got this motion, as I mentioned, just before Your Honor took the bench, and it asked you, Honor, to sanction us. I'm not going to cross that bridge because you're not crossing that bridge yet. But I also think that that's important for understanding why they have attempted to put up a smokescreen and just avoid the real issue here, which is, did they comply with the statute? They will do everything under the sun to divert Your Honor's attention. I know you're smart enough to not let that work, but that's what they're doing. They're just throwing up a smokescreen, hoping that you'll be so overwhelmed with the idea that we might actually ask for documents related to a criminal case that you're going to be blinded to the real issue here, which is, did they comply under the law? And we think that they did not.
Thank you. So, Ms. Alabi, it's technically your DV motion if you'd like a brief rebuttal.
Just briefly, Your Honor.